Good afternoon, everyone. My name is Alexandra Schroff. I am here to talk to you today about the incapacitated adult. We're going to cover the guardianships and conservatorship basics and my initial thoughts on how to avoid them. I am an attorney in private practice. I have been practicing law for 25 years, most of which has been here in Flagstaff. And my practice is focused on estate planning and elder law. Elder law encompasses things like guardianship and conservatorships, as well as long-term care planning and planning for special needs cases with families who have special needs children. All right, so what causes incapacity in adults? Well, normally it's about getting old, and most typically that includes things such as dementia, the side effects or after effects of a stroke, Parkinson's disease. But we can also deal with incapacity in adults who have developmental disabilities that, of course, were related to birth or accidents thereafter, mental illness and addiction, and catastrophic events. Unfortunately, I've been involved in a variety of emergency guardianship cases where someone's been in a catastrophic traffic accident and no one has the ability to make health care decisions for that individual. So we're forced to move into the court system to gain that type of authority to deal with that emergency. This is just a brief overview of the sources of Arizona law on the topic of guardianships and conservatorships. The one I want to point out to you here is that there have been changes to the rules of probate procedure effective January 1st of 2020. Now, that's probably more pertinent to folks who are actually practicing law in this area, and I won't bore you too much with the details, but I just wanted everyone to know that. But from a high-level perspective, the places where lay individuals would want to look for more information, of course, is on the Self-Help Center page, not only for Coconino County, but I believe that most counties also have Self-Help Center pages that have forms and information about various legal proceedings that are undertaken here in the state of Arizona. All right, what is a guardianship? Well, it's a court proceeding where a judge is making a determination that an adult is impaired by any one of a variety of circumstances. You'll see the list here. It includes mental illness, mental deficiency, physical illness, chronic intoxication, such that that individual lacks understanding or capacity to communicate responsible decisions concerning his or her person. So, sort of a lot of words for a finding that a person is really just unable to make informed decisions on their own behalf. The important thing you have to note here is that that finding by the court is by clear and convincing evidence. Clear and convincing evidence is a higher standard than most cases that are decided in our court system. So we have a range of anything from by a preponderance of the evidence, which is the normal standard in a civil proceeding. And I think a lot of attorneys would describe that as being 51%, to something like beyond a reasonable doubt, which is the standard for deciding a criminal case, which means not 100%, but pretty darn close to 100%. The clear and convincing evidence standard, in my mind, is somewhere between the two, and if you had to assign a percentage to it, let's say it's 75%. The judge has to be very, very positive that the individual who is the subject of the guardianship is not able to make decisions for him or herself. There are several different types of guardianship. There is what we call a general guardianship. This is where the guardian is given general and full authority to make decisions on behalf of the incapacitated adult. It's very similar to the role between a parent and a minor child. We can also have a limited guardianship, and a limited guardianship is where the powers granted to the guardian are specified. For example, an individual may have difficulty making healthcare decisions for him or herself, but is able to make decisions concerning where he or she lives or what type of job they have. So the idea is to customize or tailor the guardianship in such a way as to give the incapacitated adult as much freedom and independence in the least restrictive environment possible. A guardianship can be temporary or permanent, and as I mentioned when I first started the presentation, emergency appointment can be sought and obtained if an emergency exists, and it can be done with or without notice to the alleged incapacitated adult. Okay. Additionally, we have something called a Title 14 Plus guardianship. This is a guardianship that pertains particularly to individuals who are suffering from a mental disorder, typically a mental illness, and who are currently or likely to be in need of inpatient mental health care treatment. Now, inpatient mental health care treatment means a level 1 psychiatric unit. It does not mean a memory unit in an assisted living facility. It does not mean a level 2 unit in a psychological or psychiatric facility. It means a level 1 facility where the person cannot leave unless someone lets them leave. So it's a very high level of authority, and in order to obtain this type of guardianship, you, as the petitioning party, have to provide a report from a psychiatrist or a licensed psychologist that supports the need for the inpatient authority. And because the authority is so special, it does expire after 1 year unless the authority is extended by the court based upon a motion after the expiration or very close to the expiration of that 1 year period that is supported by the report of a psychiatrist or psychologist. All right, who can be a guardian? Well, it probably seems self-evident that it has to be an adult, but certainly someone over the age of 18. It is possible for parents to do something called execute a testamentary appointment of a guardian. So this most commonly arises when we have parents with special needs children who are going to become adults or already are adults. And if the parent has been appointed by the court as a guardian, then in their wills they can appoint a successor guardian to take over for them in the event that the parent dies and the child continues to need the guardianship. We have a list of statutory priorities about who gets to be the guardian. And so a guardian or conservator who's been appointed as such for the incapacitated adult in another jurisdiction, another state, has first priority. It's then followed by someone nominated by the adult, if the adult has enough capacity to do so. And certainly in durable financial and healthcare powers of attorney, individuals can also nominate guardians and conservators prospectively, should they need one down the road. But if none of those things happen, the statute does give us a list of who then has priority, and it's who you would expect, right? Spouse first, adult children, parents, individuals who have lived with the adult, and individuals who's receiving benefits on behalf of the adult, like who's a representative payee for Social Security benefits. And then if there's none of those folks, we have the Veterans Administration, a licensed fiduciary, and a public fiduciary. So let me stop right there and describe to you what I mean by a licensed fiduciary and or a public fiduciary, because some of you may not know what that means. A fiduciary is a term of art that in this particular instance applies to an individual who has been licensed as such by the Arizona Supreme Court. So in order to become licensed, fiduciaries have to complete a training program, an internship, really, so to speak, for a certain period of time, and they have to take an examination, which of course they have to pass, in order to become licensed. And as such, they are subject to the supervision of the Arizona Supreme Court, or the Fiduciary Board, which operates under the Supreme Court. for the balance of their career, very much the way lawyers are subject to supervision and monitoring. A public fiduciary is also a licensed fiduciary, but they work in the public sector. So what that means is that every county in the state of Arizona has a public fiduciary's office. And the public fiduciary it's a public entity that provides fiduciary services for individuals who can't afford to hire or pay for a private fiduciary, or who don't have family members to act on their behalf. So they are considered a fiduciary of last resort, and that's why they're at the end of the list. Okay, what's a conservatorship? Well, a conservatorship is the financial side of a guardianship. It's equivalent to a guardianship, and let me distinguish it this way. A guardianship is the authority granted to make personal decisions on behalf of an incapacitated adult.